Good afternoon and welcome to another edition of WARF Essential Topics. My name is Laura Heisler and I'm Director of Programming for the Wisconsin Alumni Research Foundation. And we are delighted to bring you this series throughout the year on topics that matter to the UW-Madison community, especially as relates to technology commercialization and technology transfer. Today's session is part of a week-long series of events led by the Discover to Products Office, or D2P, through Startup UW-Madison Week. The week is coming to a close on Wednesday, and we have WARF has featured an event every day. We have a couple more I want to tell you about very briefly. So tomorrow at this same time, we'll be having a conversation about bringing more diverse inventors and entrepreneurs into the entrepreneurial process. And we're going to learn from some other universities across the country about programs that they've started that have been really successful that might be good models for UW-Madison. So you might care to participate in that. And then we'll be ending Startup Week with a bang with WARF Innovation Day, which is an annual event. This year it takes place entirely online at 2 p.m. on the 18th. If you're interested in signing up for either of these remaining events, you can send us an email at info@warf.org or go to WARF's website and go to the programming tab and you'll see ways there to click and sign up. We do have to send you a Zoom link, obviously, like we did today. With that, I just want to mention a couple of details for how we're going to proceed with today's session. We're going to use the Q&A function, which you can find by mousing over the bottom of your screen, to field your questions. And we want to encourage you to ask questions at any time of any of the panelists or the moderator using the Q&A function. And depending on the nature of your question and how much time we have, we might respond to it orally or the panelists might respond by typing. So feel free to bring those questions at any time. With that, I am delighted to turn the podium over to my colleague, Stephanie Adamani, who is General Counsel from WARF. And Stephanie will introduce the other panelists and get things started. Stephanie, over to you.
Hi, everybody. Thank you, and good afternoon. I'm happy to be here with this great panelist, this great collection of panelists who really know this topic a lot better than I do. And I am General Counsel at WARF, as Laura said. Why would a WARF person be moderating the panel? Well, one, we're hosting the session, and two, from time to time, we do end up navigating some conflicts of interest. As many of you know, WARF is the intellectual property manager for the University of Wisconsin, so we receive invention disclosures and other disclosures of intellectual property from the university. From time to time, we have to examine whether or not there are other rights to the intellectual property that is disclosed to us. So we want to make sure that there's a clean path about who owns the intellectual property, what funding might have been involved, or what other activities an inventor might have been involved with that give rise to that intellectual property. So here today, I have a group of people from the University of Wisconsin who are going to talk in a little bit more detail about the process at the university, the things that they encounter, how things work, and then we'll all be able to answer any questions that you have as we move on. So I'm going to allow these panelists to introduce themselves and talk through what their experience is, where they sit within the university, and what types of issues they encounter, as well as the processes and rules and regulations that they deal with. And then, as Laura said, we'll have time for some questions and answers afterwards. So first, I'm going to turn it over to Brian Fox, a longtime employee of the university with extensive experience on this issue. And so, yeah, with that, I will turn it over.
Hi, thank you, Stephanie, and thanks everybody who logged in to listen to us talk today. My name's Brian Fox. I'm the Associate Vice Chancellor for Research Policy and Integrity, and I'm also the chair of the Department of Biochemistry, and I've been very fortunate over the too long time I've been here to have so many good interactions with WARF, so it's a pleasure to participate here.
Andrew, do you want to introduce yourself?
Sure. My name is Andrew Norman. I'm a senior university legal counsel in the Office of Legal Affairs. Here at UW-Madison, we represent the employees and decision makers here on campus. I've been in that position for a little over 10 years now. Prior to that, I was in a litigation practice focusing on intellectual property litigation. So I guess I always wonder what happens when you see it go wrong first before you see it go right a bunch of times. So that's the perspective I bring to these kind of arrangements.
Great, thank you. And Bob Gratzel has also been at the university for quite a while in a variety of different roles. So Bob, can you talk a little bit about your role at the university and experience?
Sure. I'm Bob Gratzel. I am the Assistant Director of Contracts at the university. I work in research and sponsored programs. I've been on the campus for just shy of a decade now, working through the different mechanisms of research-based contracting on this campus. Our team handles the sponsored research agreements and agreements that support the sponsored research, such as material transfer agreements, service agreements, stuff like that. And we're really seeing, we're really taking these things from the perspective of conflict of interest, of making sure that as we're entering into these contracts, the right procedures are followed before we sign off on the contract at the end of the day.
Thanks, everybody. So I think that the structure that we're going to have today is that Brian is going to do a presentation about what he sees and some of the things that he deals with, and some of the university's practices and policies. And then we'll turn it over to Bob and finish up with Andrew to give it. He'll give his brief presentation, and then we'll do the Q&A portion. So thank you, Brian.
Okay, should I just share my screen and go?
Yep, that sounds good.
Okay, thank you.
Thanks.
Sure, and I need to put this up for you all. Share. Okay, well, so I want to give a little bit of an introduction to the discussion today and then cover a few ongoing and newly arising topics in professional conflicts of interest, writ a little larger than just financial entanglements. And so outside activities, just a summary here, is there are two major classes of outside activities at the university that professionals want to be aware of. One of those is significant financial interests that relate to your university responsibilities. That typically includes research, but it might be teaching. It could be your service or other outreach activities. And then your commitment of time to those outside activities. And for the last 20 years or so, we've made a lot of focus on significant financial interests, particularly in the relationship to your federally funded research program. But time commitments are more and more coming to the forefront as a type of conflict of interest where someone might choose to devote time to an outside activity at potentially the expense of their teaching program, their research, or other university responsibilities. Another area that has emerged in the last year and a half or so, 2 years, has been an increased awareness of international activities and the potential for conflicts that might arise for an investigator's responsibilities to their university or to the funding received from the federal government and programs in international countries. And then finally, another change for us all to be aware of is Wisconsin Statute 946.13. This is the self-dealings law. Our university responsibilities for managing the implications of the self-dealings law, which is essentially being on both sides of a contract for an investigator that owns a company and seeks to have university funding from that company, is a nuance for us, and we'll talk a little bit about that today. So this is an ever-changing landscape. I have just listed on this URL, I have listed URLs on this page for you for referral, especially down here at the bottom, but we have UW system requirements, we have state of Wisconsin requirements, and we have federal regulations if we're the recipient of a federal grant. All of these apply to us in our position as a university employee. Let's see, go to next here. So UW-Madison has a perspective on outside activities, and an important one. We encourage our faculty and staff to engage in these outside activities. This has often been called the Wisconsin idea. We share our expertise with the community around us, the state, the nation, even the world. We're very active in transferring intellectual property from our university work to the private sector, and WARF's been just the astounding partner example of this through the years. And so that is part of our culture. We believe it's true. And the university in that context asserts that conflict of interests are common. They're frequently unavoidable for professionals who have to make choices about allocation of time, investment of effort, receiving compensation to provide good, sound intellectual advice. Conflicts are not inherently bad. They're a representation of a set of circumstances. And the university very strongly believes that conflicts of interest can be managed by using a series of best practices. These are called the management plans that many of you have heard about. And I will just lay it out. The very, very best practice for managing your conflicts is disclosure. That's early and often to anybody and everybody who might be able to help you out to negotiate or work your way through the complexity of having many hats to wear, having many responsibilities in the context of the laws and regulations that surround us and impact us as state employees when we work at the university. So another aspect that has arisen is a need or a sensitivity of the US federal government, particularly to the interactions of individuals who receive grants from the federal government, research grants, and their interactions with foreign entities. This could be either academic research institutions or companies. The concern is whether there is duplication of research or inappropriate or undisclosed transfer of intellectual property generated by the support of the taxpayers of the United States. Both time now in this new era, we're learning and regulations are changing, but UW-Madison expects that our investigators that are engaged in foreign activities, research, consulting activities, travel events, both the time and financial compensation, if received, need to be reported to UW-Madison in the outside activities report. Honoraria for professional appointments, research funding, travel support also need to be reported in bio sketches and other support pages in federal grant applications. Now, some of you may have heard of programs like the 1,000 Talents program from China that operated for several years that are part of the origin of the concern here. The RSP has a very nice, clear website on other support information for investigators that are working with foreign entities. I want to end this part by saying UW-Madison considers collaborative interactions with scientists wherever we can in the world to be the utmost of importance for scientific freedom and for the most rapid advances of scientific discoveries that benefit all of humanity. And so what we want you to understand is there are reporting requirements. There are ways to document what you do, and there are best practices here also. I listed here on this page some contacts. These are active URLs. I guess someone would be able to see the PDF from this later. Office of Research Policy in the Vice Chancellor for Research and Graduate Education office is a group that I run. We do the outside activities reporting process for the university every year. The dean's representatives in the schools and colleges are also great sources of wealth of information for you if you have any questions, and don't hesitate. It's better to ask a question first and get on the right path than to make mistakes and fix it up later. BioSketch and other support, there is great information from UW Research and sponsored programs on that, and a specific page on international research collaborations that I would refer to you. But again, reach out to contact us in the Vice Chancellor for Research or any of the panelists. And so that's the end of my slides. I'll stop and stop sharing my screen, and I could either, it looks like there's something in a chat. Laura says, you're welcome to use the Q&A tab. So
Yeah.
any questions from anyone? Or great to see the participant list is growing and growing.
That is great. I think we're going to hold the questions until the end so that we can answer them kind of all once they've all come in. Brian, I liked those resources, and I think that's such a great message that conflict of interest sometimes has a negative connotation, but it's really just a process, disclose and manage, and that people have conflicts, and there's a process for managing them, and the clarity is the important part, and the disclosure. So thanks for that.
Absolutely, thank you.
Bob, let's turn it over to you for your presentation now. Thank you.
So I don't want to, there's a couple slides in here that I'll go over. I don't want to retread a lot of what Brian said. But I mean, the big thing when we're looking at conflict of interest is, as Brian said, the Wisconsin idea that what we do here needs to influence lives beyond the boundaries of this campus. And as a campus, we do encourage our researchers to work with industry partners to start up their own businesses and to, in some cases, consult with outside entities. They have a portion of their effort that is able to be dedicated to that, and we encourage that. And the thing is, with doing these outside activities, with engaging in these partnerships, whether it be a startup of your own or consulting, as Brian indicated, it is creating conflicts as these move closer to the university. But it isn't a deal breaker. It's not the end of the world if we have a conflict of interest, and it's something that really just needs to be recognized as we're going through this. We need to recognize that there is a conflict. As Brian said, early communication is key, and then from there we work to develop management for these conflicts of interest. One of the big ones that I face on, I don't want to say a daily basis, but one of the big ones that we face at RSP fairly frequently is the Wisconsin self-dealing statute. I try to distill it down as simple as possible. Norm, you can always tell me that I've overly distilled this down, but it basically makes it illegal for a state employee to participate in making a contract between their private interest, whether that's their company or their consulting arrangement, and the state, where the employee themselves controls whether or not the state contracts with that private interest. We've had discussions about this on campus. It is a felony statute. It's something that we want to use, we want to avoid, we want to protect our researchers from being considered in that category. And the nice part about the Wisconsin self-dealing statute, if there is one, is that it does have an exception. There are limitations. Built within the statute is the limitation that it doesn't apply if the individual has worked with the university to put in place a conflict of interest management plan. This is actually a change for anybody that's gone through the process. It changed about a year ago, and we got everything up to speed this past February, where the old rule required a certain period of time that you have to wait and disclose to the Board of Regents before you can sign the agreement. The new rule simply just requires us to have a management plan. And the university has worked with the Board of Regents to develop what that management plan has to contain. And Brian's group has been working tirelessly since this all got changed to upgrade the management plan so that we're fully compliant and hopefully able to speed up the process of entering into these agreements. But so that really does speak to the self-dealing solution that we have. The big thing is, as Brian said, communicate early. Notify administration of what you're planning on doing. Notify RSP if you're going to have a conflict of interest or an outside activity, and really just try to bring your plans forward early. The earlier you do this, the sooner we can get the management plans in place, the sooner we can take a look and say, okay, this is what the situation presents. This is what we need to do to try to avoid a conflict problem. Obviously, a faculty member or a student that is entering into these relationships or engaging in these outside activities is going to be, in some respects, on both sides of the ledger. But how do we make that workable? How do you make it so that we're within the bounds of the statute and doing things, I guess, for lack of a better way to say it, doing things legally, the way the state would see it? Having that conversation, trying to make sure that you eliminate the appearances of the overall conflict of interest, that you're using your university resources to leverage a better deal for your collaborator or your company. Making sure that we have the right pieces in place is really key. And so planning ahead is big. And then, as I said, there's management plans, and you get your management plan by working with the conflict of interest committee. They will put it in place for you. Once we have that in place, it does, in a sense, free up some of the things that we need to do. It makes it a little bit easier for us to engage in the activity and the sponsored project. There's still going to be a conflict of interest, but the idea behind this is that we have it managed. You'll, as a faculty member, as a student, if you have a management plan, you want to pay attention to what's in that plan to make sure that you're doing what it's calling for at the end of the day. But the big thing is just don't panic. It is something that happens, and it's something that the university, in a sense, encourages that our faculty members engage in these activities as long as we do it properly. And that goes to Brian's statement again of being proactive, being thoughtful in how you're going about this. And for me, especially in research and sponsored programs, the sooner you let me know what's going on, the sooner you work with me or your dean's office, the sooner we can make sure that these plans get put in place and then, sorted through with the agreements. That's actually really quickly in a nutshell where this all comes down to. The rest of it is just processes behind the scenes that we have to make things work, and then just making things work for you.
Thanks, Bob. Sounds like that's a positive change in the law that allows things to move more expeditiously.
It was a big deal for us because it was back about at this stage a year ago. It was, you notify us, you have to wait until your agreement is fully negotiated, and then once you do that, it's a 45-day wait before the regents would, before the law allowed us to sign the agreement. So you're waiting 45 days when everything's ready to go. And it's, for us, it's a lot faster. It's still, don't get me wrong, it's not like it's a painless thing at the end of the day. I know people don't want to have to deal with the conflict of interest management plan and all that might entail, but it's less painful than upsetting a sponsor and saying, hey, great, we did this as fast as possible, but you still have to wait another 45 days.
Thanks, Bob. I'm going to turn it over next to Andrew Norman, and I'll let you share your screen and do your presentation. Thank you.
Thanks, Stephanie. I'd like to thank Brian and Bob for the good information so far and echo all of it. And I'd really like to thank Brian for pointing out that I can tell how many participants are watching. So that's something I can sort of obsessively look at and see if I'm doing a good job or not. So you all better stay, otherwise I'm going to feel bad about myself. So you're stuck. because you don't want me to feel bad about myself. So let's see if I can share this correctly. First try. All right. Let's see. As everybody's mentioned so far, this is the kind of thing we want to encourage, and the fact that we're having this presentation, the fact that D2P exists, I think is all an example of that. I guess this is where I come in and just give the caveats that so long as, we want to support these relationships, startups and consultancies and things like that, so long as the outside activity is not conflict. We've talked about that. We talked about the fact that it can't conflict with system or state rules or statutes. Potential conflict of interest are managed. And then the thing that I'm going to spend my time on, where this can, really good intentioned ideas can go bad, is if the contract that discusses, especially consulting relationships, but contracts that startups might enter into, sort of are bad in and of themselves and don't accurately convey the type of relationship that perhaps the campus researcher wanted to have, or the type of information exchanged that is appropriate. So agreements with third parties. The first thing that I have to do every time I discuss a consultancy agreement or something like that is to sort of give the big disclaimer that if you are doing your own startup work, or if you are acting as a consultant outside of your university work with a third party, a company, a sponsor, that kind of thing, it's important to understand that you're not doing that as an employee of the state of Wisconsin. Now, what does that mean? I think the big thing that means is that there won't be liability protection or indemnification provided by the state if things go poorly. So, hopefully you have a business entity or something that can help manage sort of the potential liability, but it's not something the state can be responsible for if you're out on your own as an individual. To a much less important way, it also means that I can't provide legal advice to anybody necessarily on campus who comes and says, this is something I'm doing in my own capacity. What do you think about this contract? So it's a limitation, because I can only represent the university and the state, and I can't represent individuals that aren't in their employment capacity. So, we never want to turn people away. So if you have specific issues that you think the university's perspective on an agreement might be appropriate, we're happy to look at them and give you sort of the university's perspective on it, but we can't act as your legal counsel. If there's big money involved, if there's big terms involved, if there's a lot of intellectual property involved, if you have a large book of intellectual property coming into the relationship, it might make sense to obtain your own legal counsel to make sure that sort of your interests are being represented in the negotiation. I did include a link to the University of Wisconsin Law School's Law and Entrepreneurship Clinic. They have a service where if you go to them with your consultant agreements, they'll take a look and help negotiate. That's a win-win as far as I'm concerned, because we got law students acting under licensed attorneys to get some practice in how to advise entrepreneurs. And it's an inexpensive way to obtain legal counsel for these kinds of issues. So we've talked a lot about the Wisconsin idea, and I love the Wisconsin idea, and I think it's important. And I think it's important to understand that companies don't operate under the Wisconsin idea necessarily. Now, the last thing I want to do is paint all companies that we might work with or all for-profit entities or anything like that in a negative way. But I do think it's important to understand that whereas largely our mission is to disseminate knowledge for the betterment of humankind and to share and to publish and to do all that, that's not necessarily the motivations you're going to find when dealing with a company. Sometimes the thing that they really want to do is make sure that you can't talk about what you've done, or that their competitors can't operate under the same science to do the same thing, to sell the same product. So just going in, I think it's important to understand that companies obviously operate different than the university, and their motivations might not be the same as yours in relation to the science you're working on, the information that you're providing. So if I had to give sort of the basics about what we're trying to avoid, what I would suggest avoiding, if I was smart enough to have somebody pay me to consult, what I would want to take out of a contract, it would be these things. The big one, the complicated one, the one that concerns me as a university attorney is obviously, a situation where a consultant would grant rights to intellectual property that isn't theirs to grant. Now, where it becomes a problem for the university is if you're purporting to grant Another is intellectual property that potentially works at the university, or whether you're purporting to grant intellectual property where the university might have an ownership interest, or at the very least an obligation to provide interest to other parties, either the federal government or maybe another third-party sponsor that has an agreement directly with the university to sponsor research. I think also it's important, and you could see the situations where it might go real bad, is you don't want to agree to any sort of limitations on future funding or research topics or publications or working with another company. These are all things that I've seen in consultant agreements, which have the power to sort of take away from your path of research here on campus, even if you've agreed to not accept certain funding or look into certain topics. And then there's some things that just it's just a good idea personally to avoid giving warranties of non-infringement, or warranties that something's going to work, or guaranteed results could end up causing you to breach that contract in a way you don't want to. So, when we talk about IP, it's a really complicated area, but, for the basics, I think it's just important that if you're going to be doing consultant work, I think the most important thing to keep in mind is, that company that's essentially buying your time and buying your effort really should only be entitled to potential ownership of intellectual property you create in the work that you're doing for them. Now, that's a very simple way to say this, and this is still get very complicated. But it's important to not then bring your university work into your consultancy contract. We don't want to have overbroad promises of sort of work you've done during a period of time, or overall promises regarding work in an area of study. Rather, if you create something on their time under their scope of work, that would seem to be a pretty reasonable request for them to own that. But anything other than that could get you into some trouble. It's especially true if you've received federal funding for your university work. It's something that we're concerned about here because I think it's probably the next slide. Yeah, because of the ownership structure we have on campus for intellectual property. I don't know, I guess it's fairly well known that the University of Wisconsin is sort of unique in that it doesn't automatically claim ownership of intellectual property created by its employees when they're doing their research and their studies. We're pretty much everywhere else you go, on the first day you start working there, you sign something assigning all your intellectual property to the institution. We don't do that, so we allow the researchers to keep their intellectual property, subject to two fairly large caveats. So the first is, when we receive federal funding because of the Bayh-Dole Act, the university does have an obligation to obtain rights to the intellectual property funded by that federal funding, and to retain some rights for the federal government, and also to do some things with regard to licensing. And obviously WARF is the big driver of that process. So the last thing we'd want to do is give some federally funded invention or federally funded knowledge to a company through an inappropriately signed consultancy arrangement, because the last thing we want to do is have to tell the federal government that, I'm sorry, we've given that intellectual property away. Luckily, that's not something we've had to do very often to my knowledge, and it's something we want to continue to avoid. A close second of something I would hate to do would be to tell a company that's funded a large amount of research, or any amount of research for that matter, at the university that, when you funded this research, we told you we were going to give you the right to negotiate a license to it. I'm sorry, that's been given away to another party through a consultancy agreement, or through an agreement that the individual researcher signed on their own. That's like another not fun conversation to have. Talking a little bit about copyright, which is a different category from sort of the inventive inventions and patentable inventions. Slightly different with copyright is the law generally presumes that an employer, the university, would own the copyright that somebody creates while working for the university. Again, we're a little different. We carve out, as an institution, we do not claim ownership of things that essentially you do, which result from your pursuit of traditional teaching, research, and scholarly activities. So what does that mean? Well, so when I give legal advice, right, I don't believe that I have copyright in that legal advice, because it's not the pursuit of traditional teaching, research, and scholarly activities. It's me being an attorney because I'm being paid by the university to do so. So that's different than the things you create in your research. Those are generally owned by the researcher on this campus. There is an exception for substantial institutional resources to support the development of a copyright work. that doesn't come into play very often. That's not, the resources aren't like overhead, right? It's if there's a very specific expenditure made to create a video or to do something like that where there was substantial university resources. The university might seek to claim that copyright resource, but other than that, scholarly activity should not be covered. So given this ownership framework, it creates a little bit of a dangerous situation where we have this ownership of intellectual property either by the university or rights to a third party that can be created in your employment here, but then sort of in your free agency where you're doing consulting work. What happens if you've made the same promise to both people, and how do we prevent that, right? So the main way we can do this is through avoiding commingling of research. It should be very clear the work that you're doing for a third party. It should have a scope of work. It should have a start and end time. It should have a topic. It should have a sort of agreed upon scope of work that doesn't overlap with something you're doing for the university or something you've done for the university. If you're pursuing the same question at the same time for two different entities, that's a good way to have a real big fight over who has rights to what you do during that time. So avoiding commingling and being very clear in your mind, this is the type of work I'm doing as a non-university employee versus this is the type of work I'm doing as university, goes a long way. You know, and sometimes it's a little sneaky the way that this can come up. I've seen plenty of agreements that basically say, consulting agreements that basically say, you agree to assign the intellectual property you create during your consultancy to us. Now, what does that mean? Does that mean during the 6 months of the contract, or does that mean when you're actually sitting there working for them? Right? It's important to make that distinction, because if it's during the 6 months of the contract and you did university work during that whole time, that's a very broad assignment of things you probably didn't want to assign. And then there are some other ways where you can get into IP trouble in a consultancy agreement. One would be a request for background rights, essentially the intellectual property rights necessary to operate and to utilize the invention. I can't imagine in my personal capacity ever agreeing that I would be transferring background rights. They may not be mine. You don't know necessarily what background rights are necessary before you create an invention. That's something that I would avoid, and a good way to get in trouble. We already talked about all intellectual property rights created during the term of the relationship, but that would also be improper. So one of the ways that we've suggested combating this is, you know, sometimes these contracts are very long, and sitting there in sort of negotiating every piece to include the university doesn't make a lot of sense. But we do have some suggested terms that we've seen successfully put in some consultant agreements before. This is the long version. This would resolve most of my intellectual property concerns as an attorney for the university if it was included in the agreement. We recognize that that's a lot of words, so we also created a short version, not as good, but potentially more likely to get into the contract. Essentially what these do is set the stage for sort of the university employment being recognized by the third party, understood and agreed to, that nothing comes in front of that. The other nice thing that proposing terms like this can do is start a conversation, right? If I was going to enter into a consultant agreement and the party that I was entering into it with objected to language like this, I'd want to know, and I'd want to know why. And I think it'd be a good conversation to have to make sure we're all on the same page regarding what I'm doing for them and what they believe they owe, what they believe they would own at the end of it. Try to go through the rest of this a little bit quickly. It's not IP stuff necessarily, but you know, there's a lot of ways that there can be terms in an agreement that makes it hard for you to do all the work you want to do in the future, right? I would think that consultants should be wary and seek to remove anything where you agree to refrain from competing with the company, because I don't know what that means, right? Does that mean I can't have the university accept a research funding grant from a company that's your competitor? Or, you know, what does competing mean in this space, right? It's not terribly compatible with university work. Restrictions on publication are obviously a really big problem. I mean, that's sort of the main thing we do here, is publish knowledge and share knowledge. And I can understand if a company wants to say, you can't publish what you've done here. Okay, that's the exchange, right? But broad publication limitations, you can't publish on this topic for a year. You can't publish what you've learned on this topic somewhere else for an amount of time is a difficult thing to swallow, really. And then the other way that, they can sort of find yourself a little boxed in is agreeing to an overly broad confidentiality agreement, right? If you agree that everything you touch when you're working for a consultant or you're working for a third party is confidential information, and then you agree that you're not going to do certain things with confidential information, you could be agreeing that a lot of very basic things within your science, within your art, within your work are confidential, and you're not going to use them anymore. So here's some more suggested language here. To at least carve out some basic ideas of things that aren't confidential, things you could have learned elsewhere, things you knew coming in, right? Not as confidential information of a company. And then we did talk a little bit at the beginning about warranties of non-infringement. For the same reason I wouldn't grant background IP, I'm not going to promise that what I give you doesn't infringe somebody else's patent. I don't know that. I don't even know what I'm going to give you. How can I know that what I'm going to give you isn't going to violate somebody else's patent? I haven't done the patent search. I haven't looked into it. So I think that that would be a bad idea. At the very least, we could see that last bullet, we suggest that you will refrain from knowingly providing deliverables that infringe another party's intellectual property or knowingly sharing another's confidential information with the company. That should go a long way. And then there's some other things that can result in significant personal cost if things go really poorly and you don't expect them to, but I don't think that it makes sense for a consultant to indemnify, to pay the legal bills, to pay the obligations of the party that's engaging them as a consultant. If you do get in a fight, do you have to go fly out to California to adjudicate it? Is there some long process where you have to arbitrate, to figure out what's going on in the contract? And again, long restrictions on confidentiality is something that could be a problem. I guess the last thing I'll say, and maybe Stephanie can talk about this a little bit too, is I guess I would just think a little bit before, especially if we're talking about low money consultant arrangements where they're asking you to sign a contract. In my experience, I haven't seen necessarily that the length of the contract is at all related to the amount of money being exchanged. I've seen $600 speaker contracts that are 10 pages long and start, putting a cloud on intellectual property. I don't know that that's a good idea for anybody, right? Because I know when WARF gets an invention disclosure and sees something like that in there, I think that's a negative. And I think it's worth asking yourself whether such an arrangement is worth it, especially if you're doing somebody a favor. If you're just going to speak somewhere and it's a small amount of money, I can't even imagine why the contract would talk about intellectual property, and I can't imagine a situation where I would think that's a good idea. That's all I have for slides.
Great, that was so helpful and practical. And I think we've seen all of these things in contracts before. So it really is important to pay attention to what's being signed. I even recall the confidentiality agreements, visitor agreements, having things embedded to them that relate to these topics. And while that's a little bit outside of the classic conflict of interest, it is more encumbrances out there that you might not be particularly aware of or wouldn't expect to see in those types of contracts. So paying attention, really important. I did want to add another a caveat that we're always encouraging inventors to disclose IP, disclose inventions once at the earliest possible time, including if it's not even quite to the stage of what you might think of as an invention, but disclosing the intellectual property that already exists prior to these contracts, to disclosing it through the university and WARF process helps to really segregate that out and kind of mark that point in time. So that's always a good practice, something we encourage anyway, but wanted to mention that as well. So let's see, it looks like some of the questions already have been answered that have been posed, but I wanted to open it up to the panel to see if you had any questions for one another at this point or wanted to make any points. And if not, I have a couple questions that I have ready to ask as we wait for more questions to come in.
Well, I think I did answer to Jenny Gumperts, and thank you for that question, Jenny, about if my effort adds up to 100%, how could I report my outside activity or my work in China or something, because I'd be more than 100%. And I think what you've done is you put your finger right on the issue of how do we account for our time and that potential conflict. And so what is, again, to come early, disclose what you intend to do and have the discussion with the dean's office or your chair, dean's office, on time commitments, so that we can what the piece, the guidance piece that one would use about understanding an outside activity is, does participation in the outside activity affect your ability to carry out your responsibilities as a university professional, your teaching, your research, or your service? And if the assessment is no, then you can go ahead and proceed with the outside activity. If the assessment is yes, then we need to come in, we need to have some kind of an agreement management plan of how much time to commit, when in the year one might commit it. I mean, it's a very different type of time commitment for me when I'm teaching my class 3 days a week in the spring as compared to the summer or the fall. And so, depending on the time of the year, it might be appropriate to be involved in an outside activities to a larger extent than in another time. But it's not, it's better if the individual doesn't make that assessment, but they let other people at the university view the circumstances and give some guidance on that.
Makes good sense. I want to go back to one of the answered questions, and that had to do with what happens when there's a founder in a startup who is an inventor on WARF IP. And I'm going to presume then that that founder of the startup is still also a researcher at the university. So we've got a founder of a startup. And I want to say, like, we really are excited about the entrepreneurship that's happening in Madison and in the state and on campus. So you've got that happening. And then you've got a researcher who came up with some inventions on campus and has disclosed them and presumably assigned them to WARF, maybe with multiple inventors on them. And through the contract where that IP is assigned to WARF, WARF agrees to share with the inventors royalties, some of the money that come in when that product or when that invention is commercialized. So there's a possible kind of return for them as an inventor, and then they're also sitting as a founder of a startup. So that is kind of a situation I think that we see, and WARF is always looking for the best opportunity, the best home for the technology, and the place where it's going to be most likely commercialized. And sometimes that is the startup. And so we are in that position where we're licensing IP back to the inventor's company. And that's not uncommon. But I do think one of the things I wanted to mention, or one of the things that can happen then, is exactly what Bob's title slide said. He's got, or she's got, multiple hats on because they are presumably doing some work with their startup trying to move technology forward, but then they're also researching on campus. So how have you all seen that played out, and what are some of the best practices?
Bob, you want to do that? Because this is it. This is 94613, isn't it?
Oh, Bob, you're muted.
Technology kills me again. So I would say, what we see in the situation is you have a PI that is an inventor, and they're also the owner of the startup. And where we're going through this is, the first thing that we're doing on the sponsored project side is we're going through the agreement, and we're seeing this conflict, and we're searching the database to say, is this conflict managed in the first place? The university has a database of all the conflict of interest management plans, who's disclosed outside activities, It's been kept up to date as best as people are disclosing. So we're going through and making that determination. Um, I believe as of February of this year, most of the conflict of interest management plans have been updated to the Board of Regent new requirements. So as long as we're going in there and seeing that there's a management plan in place, and then the management plan has been signed since February of 2020, we should be fine. We have that conflict of interest taken care of. So the statutory issue is sort of, it's still there, but we've got it managed in the sense that the legislator wants us to have it managed. If we go in there and we see that there is a disclosed outside activity and it's not managed, that's the point where we reach out to Brian's office, the conflict of interest committee, and say, hey, we're entering into this agreement. We really could, we notice that there's a conflict of interest or an outside activity, it's not managed. Can you work with the faculty member or a student or whomever to get this managed? And that's a conversation that happens in the background, but we're monitoring it to make sure that once we get the agreement negotiated, that a management plan has been put in place, it's been signed, everything is compliant with the law. The other thing that we're doing, at least in sponsored projects, is we're taking a look and making sure that the right names are in the right places. So let's say that your faculty member or a student, let's go with faculty member just because the student thing can be a little bit more convoluted, but you're a faculty member that's the PI on the project, but you're also owning the company and you're going to sign the agreement. At that stage, we really would want somebody else, if we can, to be signing the agreement on behalf of the company. So we know that you're on both sides of the ledger, and that's what our conflict of interest management plan is, but we would really like somebody else to be signing it so that it doesn't overtly look to the legislators like, okay, are you sure that you've really managed it? Because now this person is really doing, wearing the hats and overtly, entering into these agreements with the university. And that looks a little bit strange. It's something that comes up for us when we do outgoing sub agreements. We don't want this person that's approving the activity also to be the one that's invoicing us, because now you're just approving your own activity and it looks strange from a funding perspective. So we're going about that. The other thing that I've seen with a lot of our dean's offices is that they're reviewing these conflicts of interest in these agreements and really trying to advocate that, what we're offering these startup companies, we're offering this faculty members company is a fair deal. Not that we're going in and saying, okay, you're a startup company, the faculty member owns the startup company, we're going to give away all the intellectual property for free to the startup company. They want to make sure that we're treating people fairly and we're not, giving an unfair advantage to the company because the PI is also the owner of the company. That it looks kosher from the outside, really is what the goal is.
Thanks, Bob and Brian, for discussing that. I did have one question, and I'm just naive on this point, but if you have a PI who has a conflict and has a management plan and is still doing research in the lab, how are the grad students involved in that? Or would they be just part of what's going on in the management plan? Or can you speak to that a little bit?
Maybe I should do that since I've had a management plan and I've had grad students under them. So the disclosure part about a management plan with graduate students is that whoever let's say it's the faculty member in this case, tells the graduate students, other staff in the laboratory, perhaps other co-investigators, collaborators, that they have this financial interest in a company related to their research. I usually take that as an opportunity to talk to my graduate students about this is part of the professional life, right? It's a conflict. The conflict is that I have an obligation to carry out some research, and maybe I'm a consultant to a company, and I'm receiving a financial payment for talking to them about my work. And so I think it's fair and it's educational for me to tell my graduate students that I'm doing this. And what does a consulting agreement do? Where's the overlap? The management plan asks that we tell the graduate students that if they have concerns about this outside activity of the faculty member, they can contact a party outside the lab. So a department chair, a dean's office, people in my own office in the vice chancellor for research to discuss the issue. Graduate students can carry out research under a sponsored contract where even the faculty member is a PI. That's not infrequent here. We often ask that the PhD committee have a little bit more role in guiding the students and assessing that the progress, well, that the work being carried out, first of all, is meritorious research leading to a thesis, and that there's good progress toward the goals of the student, not the company. So maybe I'd stop there. Graduate students are integral part of it. We really want them involved, and
Thanks. I think
try
that
to
the way you described that really kind of drove home for me the like level of professionalism that you're dealing with, and also really that it is something expected and common and something to be managed. So I really appreciated that. And I see we have one question open. Could you give a hypothetical example of a case where there is a potential conflict and how the university might resolve it with the staff or student? So I guess this to me is a question kind of we've talked through a few examples of how there could be a consulting agreement or a sponsored research or a faculty inventor in a startup. So what does a management plan really look like then?
I can give you one. Hopefully this is along the line. I mean, there are many hypothetical cases, but I'm gonna try to involve the conflict in staff and students. So our management plan requires that students can publish the results of their work. I mean, we don't do classified research here. All the research that's done in the university, we assert should be published for the published good, even work carried out by industrial sponsors. And so there's one way where very simply, and even before anything really gets started, the management plan tries to manage and resolve this potential conflict of, well, the company may not want to publish this. They just may want to keep that kind of quiet or not let their competitor know. But by engaging with us in a contract and in the context of a management plan, university is going to assert that, yeah, the staff or the students have the right to publish their work. So that's one way. I'll try to think of another one. Maybe Bob's got an example too from something around contracting or. I mean, I think a lot of what Bob said about you can't be on both sides of the contract is a way that we really help to mitigate the sense that a student might be just used as an employee, not doing meritorious research leading to a thesis.
Okay. Thanks.
I mean, so what I can say is I can use maybe it's a hypothetical based off of an actual real world example. We don't know, we as a university rely on self-disclosure. We rely on the faculty member to disclose to us because we really don't engage in that investigation. For our part, there are certain situations though where we might notice that there's a conflict of interest. An example might be that the company that we're dealing with just so happens to have the exact same name as the last name of the faculty member or the staff or the student. And let's just say for purpose of this, that's a very unique name. So the likelihood that it's not, they're not related seems very low. When we see a situation like that, at least in research and sponsored programs, what we're doing is we're reaching out to the dean's office first and saying, we checked the database. There's not a management plan. It's not been a disclosed outside activity. Is this a conflict, or are we just overthinking it? And usually at that stage, our dean's office will take a look. They'll have a conversation with the faculty member or the student, and then they will then, depending on that outcome, will work with the faculty member or student to disclose to Brian's team. And then at that stage, Brian's team will investigate the conflict of interest and see, do we need a management plan in place or not? And, what is the nature of this conflict? In the ownership interest, you probably do need a management plan. And then at that, they will then go forward with making sure that, they have the management plan, has all the details that the Board of Regents requires. I don't know how much discussion happens, but I believe that there's an informative conversation of like, this is what this means to you, probably with the dean's office, but possibly also with Brian's group. But what does it mean that you're entering into this management plan? And, are you okay with doing this? Is it something that you can do, or, do we need to figure something else out? Hopefully that there is not really much of a conflict. You sign the management plan and then we move on. I don't know, Brian, if there's any instances where that, there is a conflict.
I'm going to step in because I know it's time to wrap up. I just got the note, but I think this has been a great discussion, and hopefully people got the point is disclose, and there are many people and tools to help manage. So I really thank everybody for their preparation and wisdom on this topic, and hope that the audience found it useful as well. I know Laura put a plug for the next event in the chat, so hopefully we will see you there too. And want to really give a shout out to all of you who participated on the panel. I learned a lot, and I appreciate having you all as a resource. Thank you.